back in my guest, actually a new guest this hour, former federal prosecutor and former Department of Justice senior attorney, Tammy Allison. Tammy, great to see you again.
Thank you for having me, Michael.
All right, now you heard it was a quick verdict, under an hour, something I don't think I've seen. I was trying to remember if I saw anything under an hour. I haven't. Your reaction to the verdict and also the timing of it.
Under an hour to a jury foreperson who was sniffling and crying as she read it. You know, I thought it was a little suspicious. I think that it's screaming jury misconduct somewhere. If the defense attorneys are paying attention, they should be writing all the notes for a motion for a new trial. You know, I have never really, I don't think in my experience I've ever heard of a jury foreperson crying while they delivered the verdict. But under an hour, it seems like she was hesitant to even read the verdict of guilty. So I'm interested to see what the defense attorney's next play is.
Well, can you dig into that a little bit deeper there, Tammy? This idea that the emotions of the foreperson, as well as the timing, the only under an hour coming back with a verdict, you suspect that there might be some issues with that in terms of you think they might have been talking about it when they weren't supposed to? Dig into that a little deeper for me.
You know, it doesn't really matter what I think or if I think they coulda, woulda, shoulda, but what a good defense attorney would do is pay attention to something like that, something so blatant as a jury foreperson crying as delivering the verdict whenever it was delivered in less than an hour of deliberation. It tends to feel like they didn't ask enough questions. Did they fully understand the jury instructions? Did they go back and ask the judge questions? This is under an hour that you're delivering a verdict of someone whose life is literally in their hands. And it seems to me, when the foreperson was crying, she's hesitant to even read the verdict of guilty. So a defense attorney would most likely file a motion for a new trial, and motions for a new trial tend to come up under a number of circumstances, one of which is if there could have been jury misconduct. And a motion for a new trial might relieve this defendant of this guilty verdict if he gets that new trial granted. And he's facing about what? 3 consecutive life sentences. Any good defense attorney would try to pull that move, even if it was like not even going to work likely, just so that he can say he zealously advocated on behalf of his client.
Yeah, it's an interesting point, because in that 45 minutes, you're right. They could not have done all the work you expect the jury to do. I mean, certainly there was a vote taken. They might have gone through some of the charges, but going through all the jury instructions and understanding that alone takes more than an hour, I would think. So yeah, you make a good point there. The only thing that was at issue for me in this case, Tammy, was whether they might go with the first-degree murder or perhaps the second-degree murder. I was wondering if they did enough to show premeditation. I thought in closings, the state actually solidified that issue for me, but it was still something that I thought the jury might struggle with, because at the end of the day, this was a bar fight. There was a lot going on, a lot of commotion. You could certainly understand the point of view of the defendant at certain points being attacked or feeling like he was being attacked. Your thoughts on that issue?
I agree. I think that is something that the jury would struggle with, coming up with that intent. And again, given the fact that they deliberated for less than an hour, it raises questions as to whether they actually went through all of the testimony that was presented before them, all of the different evidence, whether circumstantial or actual evidence, to really come to a conclusion of these guilty verdicts. And given the fact that this foreperson was boohoo crying, I don't know if they really did their due diligence.
You know, Julia Janae had told us throughout the trial that jurors were emotional. There were a few jurors, not the foreperson who ended up being the foreperson, was someone that wasn't necessarily emotional, but a lot of the jurors were emotional throughout. There was some horrible video, horrible photos of the blood on the various victims in this case. These were really ugly emotional type injuries in this case. that could pretty much explain some of the emotion.
It could explain it, but it also could explain whether the prosecution and defense did a good job at jury selection. There are certain questions that are asked of jury members to make sure that they can come to an unbiased determination after having all of the facts presented to them. Given the fact that there is a certain level of emotion involved here, most of it with the jury foreperson, to me, it raises some questions. And like I said, a defense attorney would definitely be scribbling in his notepad for a motion for new trial.
Yeah, and there's another issue as well, this idea of whether he was involved in illegal activity, which took away the opportunity for them to argue, the defense, to argue that he was standing his ground. And I thought that was an important part, an important pillar in the defense in this case. And the judge decided that there was clear and convincing evidence from basically the testimony of one witness, and that was J.C. Harper, a friend of the defendant. The defense had objected a number of times, Tammy, saying she was no expert. The actions that she was seeing, she was saying maybe it was a drug deal, but who is she to know what those actions were? Going to an ATM, talking off in the corner with other people, et cetera, et cetera. I want to get your thoughts on that issue and whether that might be a strong appealable issue.
It could be a strong appealable issue because the defense preserved the record for appeal by making those objections. And those objections are so important because if the defense did not object, they could not raise that or that witness's testimony or parts of that testimony in the appeal. Because of the way that she was testifying, like you said, how could she know? What prior experience does she have? Was the proper foundation laid by the prosecution to have this witness declared as an expert to opine on those certain elements? So the defense, what they did was object. And they objected each and every time, which is excellent because it preserves the record for an appealable issue that can be raised and dug into deeper.
All right, well, Tammy, Michael Mosley, found guilty of all charges, could probably end up spending the rest of his life behind bars. Stand by, Tammy. We're going to take a quick break. When we come back, the trial